State your name for the record, please.
Islam, I self-law am master and proper persona, sojourner, heritage of the land.
Good morning, and good morning, great morning. I'm Judge Lenise Bryant. Welcome to the 36th District Court. You are at the 36th District Court. You are at 36th District Court. You are at 36th District Court. You have logged into 36th District Court. You are no longer in your bedroom. You are no longer in your living room. You're no longer in your dining room, your kitchen. You are at 36th District Court. Therefore, I expect that you will act accordingly as if you are physically present in that courtroom. All right, I am finishing up my live here. All right. The other thing is that you are looking in a camera. You're not looking in a mirror. You're looking in a camera. So that means that we're looking back at you. I am going to send most of you to a breakout room. Please do not leave the breakout room. Someone is going to come into the breakout room to speak with you. Do not leave the breakout room. Someone is going to come into the breakout room to speak with you. Do not leave the breakout room. Ms. Stevenson, now today I probably do need your help. On those other days, I don't really be needing your help. But today,
Okay.
if I'm sending somebody to the breakout room that has a lawyer attached to them, let me know. So, because I don't have my printed document.
Yes, sir.
And you must be in your camera. We must be able to see you, or else I'm going to have to remove you from the courtroom. You must be in your camera. We must be able to see you, or else I'm going to remove.
Buckle up, guys. Today we're stepping inside a courtroom where the judge wastes no time setting the tone. From the very first words, she makes it crystal clear this isn't a casual Zoom call. It's real court. Cameras must be on. Respect is mandatory. You're not in your bedroom anymore. You're in the 36th District Court. The authority in her voice signals one thing. This space runs on order, and anyone who forgets that will be reminded quickly.
You from the courtroom. All right. So I'm just going to go based on my screen, because again, I don't have a printed document. So, Mr. Reader, Damian Reader, when prompted to do so, please accept to join the breakout room. When prompted to do so, please accept to join the breakout room. So I'm going to send Mr. Render, I should say, I'm sorry, Damian Render, to breakout room number 1. Deshaun Smith to breakout room number 2. Oh no, that's an attorney. Lisa Hodge to breakout room number 3. Bonita Sealy to breakout room number 4. Did Miss Stevenson leave me? I told her to help me and she left me. Ah, Lord have mercy. Miss Muldrow is this is case number 17-461-2601. The people of the state of Michigan versus Bonita Ayana Sealy. The defendant is charged with 1 count of assault or assault and battery, and today is the date set for an arraignment on a bench warrant. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 8350505.
All right, ma'am, please unmute yourself. State your name for the record, please.
Islam, I self-law am master and proper persona, sojourner, heritage of the land.
Ma'am.
All right, guys. This is where the temperature rises. The defendant responds with language that immediately signals a jurisdiction challenge, and the judge shuts it down without hesitation. There's no confusion in her reaction. Participate properly or don't participate at all. The muting says everything. This moment captures the clash between courtroom procedure and unconventional legal tactics, and you can feel the tension tighten in real time.
I said state your name.
I will state for this X-rail, this
Ma'am, listen, let me say this to you.
this
Let me say
trade
this.
name, no,
Ma'am,
this
let me
trade
say
name.
this. If you did not come to court, if you didn't come to court to participate in court, please don't come back to my courtroom. So I've muted you, so therefore we can't even hear what you're saying. So let me be clear. If you have not come to court, because let me just be clear. Okay, well, you have a great day. Have a great day. If I didn't think someone had jurisdiction over me, I promise you, I would not even get out of my bed. If a person did not have jurisdiction over me, if I believed that a person, that an entity did not have jurisdiction over me, I promise you, I would not get up out of my bed. I would not take a time off of work. I would not stop anything that I was doing for that day to come to court to say these things. Number one, you know it's going to get you nowhere. There is no, it's like speaking Spanish to an English speaking person. So if you believe, Ms. Sealy, from the bottom of your heart, that I nor this court has any jurisdiction over you, ma'am, don't come. You don't come. Because there's nothing, there is absolutely nothing. There is nothing that I can do for you. If you are not interested in proceeding in a manner that we can understand you, if you're going to simply read off some stuff to me, it's equivalent to me going over to England. Since apparently you all don't believe that you're citizens, I don't really care what you believe. It is equivalent to me going over to England, getting arrested, and then telling them they don't have jurisdiction over me. If they let me go home, I promise you, if I didn't think they had jurisdiction over me, I'm not showing up. So okay, so we can try this one more time. If you want to state your name for the record so that we can have the name for the record, then you can state your name for the record. If you're going to say all of that other stuff to me that I don't have jurisdiction, then I'm gonna subside, and I'm gonna go ahead and move on to another case. I am going to remove you.
Now we reach the turning point. The judge delivers a calm but razor-sharp explanation about jurisdiction, using everyday logic instead of legal jargon. She reframes the argument in a way that's impossible to ignore. If you truly believed a court had no power over you, you wouldn't show up. It's controlled, confident, and persuasive. This isn't anger, it's authority grounded in reason, and it shifts the power balance completely.
From the courtroom, because this is going to get us nowhere. Now, by the time you've said all of this, by the time you've done all of this, this is a 2017 case. We probably would be finished with the case by now. Probably would be. Of course, I'm not going to give legal advice. I'm not going to say what she should do and how she should respond. Probably would be finished with this case by now. Okay, ma'am, please state your name for the record.
Bonita Ayana Davis Sealy.
Thank you, Ms. Sealy, for an arraignment on a bench warrant. How are we proceeding?
Innocent.
The court is going to enter a not guilty plea on behalf of Ms. Sealy. I will set this matter for a pretrial conference. This is a child abuse 4th degree case. Strike that. Again, I keep looking down at your client, looking up at your client's case. This is an assault or assault and battery case. The court is going to set the matter for a pretrial conference. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed. Probably could have already been dismissed. I don't know if you have contact with the complaining witness or not, Miss Ritter. However, the complaining witness is required to appear at the pretrial conference. Today is December the 6th. The court is going to set the matter for January the 6th. At 8:35. I'm sorry, 8:25. That denotes the arraignment portion. 8:25. As I indicated, the complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation for the failure to appear. Bond will continue with no contact with the complaining witness. Anything further?
Nothing from the people, Judge. Thank you.
Anything further, Ms. Seeley?
Well, I would like to say something, but I see that I'm gonna just keep my peace. I'll see you guys on the 6th of January.
All right, then you have a great day and stay safe.
You too.
Thank you.
And just like that, the standoff dissolves. The defendant states her name properly, the plea is entered, and the case moves forward. It's a subtle but powerful reminder that courtroom structure ultimately prevails. Even the final "I'll keep my peace" hints at tension beneath the surface. Order is restored, but the lesson lingers. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next one.